The number one thing that you probably missed on your power of attorney document. My name is Philip Bruce. I'm an estate planning attorney here in Minnesota, and we do a lot of power of attorney documents in this office. We actually do powers of attorney and healthcare directives for free with any plan that we're doing. So we do them all the time, and because of this, we see a lot of old documents that come in that we review, and we're happy to provide some thoughts on them if folks don't want a new one. The number one thing I see wrong is this. There are two types of power of attorney documents in Minnesota. The first one is called a common law power of attorney, and this is where you get to write whatever you want. You can make pages of instructions, be very detailed about what this person can do with your finances. This is your financial incapacity document. Who can control the bank accounts, talk to the insurance companies, etc. And you can give very specific instructions with this. The issue is that nobody has to accept it. It's just an authorization. They can accept it, but they might not. Those are really useful if we're doing something like a business transaction or buying real estate. But when it comes to incapacity, we want some level of certainty here. We want to know that this thing is going to get accepted. So those common laws aren't great. We oftentimes instead want to do this thing called a statutory power of attorney. You can look this up online and take a shot at it on your own. It's available freely. Look up Minnesota Statutory Power of Attorney. We do these for our clients because there's a very specific way that we'd like to see them done. Because we see a lot of mistakes even with a very straightforward kind of checklist document like a statutory power of attorney. The nice thing about the statutory format is banks, insurance companies, advisors, etc., unless it's been waived on an account agreement somewhere, they are required to accept this if they're doing business in the state of Minnesota, or they can be on the hook for damages. And we really like that. It provides some teeth, it provides some certainty. We lose our drafting flexibility, and we have to use kind of this checklist format when we're doing these. And because of that, we got to make sure we check the right boxes, okay? So it's nice. Banks see this all the time. They're like, yep, this is great, good, thank you. But here's a couple things we want to watch out for, and one in particular is this. Towards the end of the document, you're going to see a checkbox, and it says, I authorize this person, fill in the blank, to give money to themselves. The way it's phrased is kind of funny. It says something like, I authorize my attorney-in-fact, that's the real name for your power of attorney, I authorize this my attorney-in-fact to give money to the attorney-in-fact. And what that means is, can your person give themselves your money? For kids, we're probably going to say no if they are acting as your power of attorney. But here's the thing. What about spouses? What if my wife needs to access my money? So an IRA is an individual retirement account. That's not a joint account. What if she needs to access my money to pay our bills? Well, by doing that, she is self-gifting. She's giving money to herself indirectly, but she's benefiting from it, and she's my fiduciary. She's my power of attorney. That's illegal unless we authorize it. So we almost always with spouses want to say, yes, this person, this power of attorney can self-gift, but we limit it to the spouse. So watch out for that when you're filling out that form. If you have questions on this, we take care of them all the time. Happy to answer any questions. Give us a shout or an email.